All right. Okay, we're jumping straight in. All right, no intro, no nothing. It is what it is. It's a straight read through tonight, this morning. I have found that there will be no live streaming of the Barry Morphew trial. We can all thank JLR Investigates for that. I will read these documents he has mentioned, so I'm not doxing anybody. These are on the court's website. District Court of Alamosa County, Colorado, People of the State of Colorado versus Barry Morphew. Matter came before me in the defendant's unopposed motion to cease unmonitored live streaming of court proceedings filed on September 19, 2025. Defendant's motion D009 attempts to address violations of Colorado Statute and Chief Justice Directive 23-02 concerning the recording of live streamed criminal proceedings for the following reasons. Motion D-009 is hereby granted. Both this case and the prior one against Barry Morphew have garnered an unbelievable amount of local, state, national, and international attention. If you enter Mr. Morphew's name in an internet search engine, many thousands of results return. This is perhaps not surprising considering the explosion of interest in the true crime genre with the development of podcast and streaming television in the last decade. There are more than 2,000 true crime podcasts in existence and available on free podcast services like Apple Podcasts and Spotify. Several podcasts have already covered this case against Mr. Morphew in some capacity, but this level of interest has also increased the level of difficulty a court such as mine has in protecting the right to a fair trial and the safety of those involved in this sort of case. There have been 2 court dates in this matter since the grand jury returned an indictment against Mr. Morphew on June 18, 2025. Both have been available to the public via the state's live streaming services. Following the September 2nd, 2025 status conference, it came to my attention that an individual with a YouTube channel called JLR Investigates posted a recording of the status conference, including the admonition that there shall be no recording made. JLR Investigates unlawful recording included comments from some of the 17,000 plus people who viewed the unlawful recording. Some of the commentary, including from JLR, takes with issues from the constitutional requirements that the defendant is presumed innocent until proven otherwise, propounds several conspiracy theories concerning this case. Propounds several conspiracy theories concerning this case, and threatens violence against me, attorneys for both sides, and others, including several victims. This is the judge writing this. But JLR Investigates is not the only YouTube channel that is unlawful recorded and then posted live stream hearings in this matter. I didn't read the footnotes in order. Let me read them real quick. Footnote 1 is both the content of the screenshots of the unlawful recording and the commentary by viewers was redacted in the publicly available version of Motion D-009 and will not be repeated here in this public available order to prevent further harm coming from this behavior. The unredacted version of the defendant's motion will remain available for appellate court review. The second footnote was the defendant's motion also discussed the conduct of another YouTube channel that similarly displayed this unlawfully recorded live stream proceeding and channels that recorded other concerning behavior released to this case. I took these to be examples of the most egregious behavior that unfolded after the September 2nd, 2025 hearing, not to an exhaustive list. These individuals, including JLR Investigates, will herefore be referred to as the offending observers. The names of these additional offending observers are being excluded to prevent further traffic to their channels, thus compounding the problem they created. Pausing the availability of the public's access to live streaming does not run afoul of the constitutional rights of public trial. Defendants accused of criminal conduct are entitled to a public trial by both the United States and Colorado Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. And then it goes to cite, in all criminal prosecutions, the accused shall have the right to speedy public trial. The right to a public trial belongs largely to the accused, People versus Jones. This is so that the public may see the defendant is fairly dealt with and not unjustly condemned, and that the presence of interest spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. Okay, then he quotes, contrary to the purpose for which the offending observers have used it, the right to public trials exists for the purpose of preserving an accused right to the presumption of innocence and in ensuring legal professionals provide the best, most competent service possible to the communities we serve. The right to a public trial is not without its perimeters or limitations, and it can be waived. Even constitutional rights can be waived, although I shall indulge every reasonable presumption against such a waiver. And then he quotes Phillips versus People versus Rediger, United States versus Lano. I do not find that in making a request to disallow live streaming the proceedings, the defendant is waiving his right to a public trial generally, but he's volunteering to have a limitation placed on that right. Public trials do not only belong to the accused. Rio Supra, public access to criminal trials, permits the public to participate in and serve as a check upon the judicial process, an essential component in our structure of government. And then he quotes, the benefits to make the public access to criminal proceedings include allowing the public to see the accused is fairly dealt with, ensuring that judges and prosecutors discharge their duties responsibly, encourage witness to come forward, discouraging perjury, and allowing victims and community to know that offenders are being brought to justice. Rios, the laudable purpose cease to exist, however, when some members of the public exploit access to criminal proceedings for purpose antithetical to these goals. Not every restriction on the public accesses to the criminal matters result in a constitutional violation. There's a 4-part test announced in Waller Super to determine if a courtroom closure complies with the Sixth Amendment. Has a party seeking to close the courtroom advance an overriding interest that is likely to be prejudiced? Is the closure no broader than is necessary to protect that interest? Are there reasonable alternatives to closing that proceeding? And have I made findings adequate to support the closure? The Sixth Amendment guarantees a right to a trial that is open to the public, meaning the public has reasonable opportunity to be physically present to observe the proceedings. Nothing in my ruling will prevent that opportunity. In contrast, if I do not pause the unfettered live stream of hearings in this case, at best, the unlawful recordings and venomous commentary may affect both or either party's right to fair trial by tainting the small jury pool through the prevalence of factual inaccuracies and the court of public opinion. While the impact of these outside commentary is not an uncommon concern on a high-profile case, what is occurring because of this behavior of the offending observers rise to a level of seriousness beyond that which something like a change of venue could resolve. At worst, the calls for and acts of violence against the parties and legal professionals will lead to someone being physically hurt. The Colorado legislature mandated that criminal proceedings in open court may be available for remote public viewing and listening in real time. There are several reasons for limiting this process, including that the courtroom does not have significant technology capabilities. Members of the public have been excluded from the criminal proceedings by order of the court. Technology, staffing, or internet issues limit or prevent remote observation. After request by a party, witness, or victim, or on the court's own motion, a court makes finding that the record based on the particular facts and circumstances of the case, that there is a reasonable likelihood remote observation of live proceedings risk compromising the safety of any person, including risk to physical and emotional safety, intimidation and harassment, the defendant's right to a fair trial, including violations of sequestration orders, or the victim's right pursuant to the victim's right. And there's no less restrictive alternative that provides the public's interest in remote observation while mitigating the identified risk, including allowing remote audio-only observation while disabling video observation or turning off remote observation at particular times. The status requires that the court ensures there is no audio or visual recording without the permission of the court and gives examples of what reasonable steps must be taken at the same time. The Colorado Judicial Department has already taken these steps, which it can, including several warnings that recording is prohibited. Additional measures are not possible in this situation, as explained below. The statute also allows the Supreme Court to prescribe rules of procedure in implementing these statutes. The Supreme Court has done so via Chief Justice Directive, CJD. There's this quoting, CJD provides a list of considerations that must be made before limiting live streaming. Whether there is a reasonable likelihood the live stream would interfere with the rights of the parties to a fair trial, whether there is a reasonable likelihood that the live stream would create any adverse consequence to a party, attorney, victim, or witness, whether there is reasonable likelihood that the live stream would unduly detract from the solemnity, decorum, and dignity of the court, whether any prior violations of this directive or other rules of the court have occurred in the same manner, the level of public interest in this case, consideration of Victim Rights Acts, whereby the victim has a right to be present in person, by phone, virtually, by audio or video, or similar technology for all critical stages of criminal justice process, and consideration of the American with Disabilities Act, whereby deaf, hard of hearing, and deafblind individuals may request communication access services by completing the standard judicial ADA request form. CJD 23-02. Furthermore, live streaming shall only occur when viewers conduct themselves in a manner consistent with solemnity, decorum, and dignity of the courtroom. Since CJD further confirms that there shall be no recording of any live stream proceeding, but that nothing in the CJD modifies the process for expanded media coverage. The actions of the offending observer meet the criteria necessary to restrict live streaming in this case under both the status and the CJD. First, the offending observers and some commenting in their unlawful recordings have advocated and outright threatened harm against me, attorneys for both sides, the defendant, and most disturbingly, the victims in this manner. While these types of threats towards these individuals in the justice system are unfortunately no longer uncommon, individuals who are either followers of and or like-minded to the offending observers have taken his steps further by doing things like doxing the former judge in this matter, sending threatening letters to the home and work address of attorneys involved in this case, and leaving a dead fox on the front porch of one of the attorneys' homes. I will repeat that. And leaving a dead fox on the front porch of these attorneys' homes. Stop it, people. This is beyond the pale of simple commentary on their work to hold them accountable or disagreement with my decisions or the courts of this case. These are terrifying, unlawful attempts at intimidation and harassment that have no place in our justice system. Second, Alamosa County has comparatively small jury pool. While I would never prevent general publicity of any case that is such interest to the community, that public will likely prevent at least some that publicity will likely prevent at least some of our small jury pool from being fair and impartial jurors on this matter. The actions of the offending observers threaten to exacerbate the problem by showing parts of the proceedings and its participants that the credential media, for good reason, are prevented from showing and making statements purporting to have some sort of inside information that would not ever be provided to the jury because it's not real or an actual fact. Any less restrictive remedies would prove fruitless. The Colorado Judicial Department has posted on several places admonishments against precisely this type of behavior which has occurred, recording, live streaming. These warnings were ignored and even included in the unlawfully reproduced material. Switching to an audio-only format will not prevent threats and harassment towards the parties of the victims. Even if the audio is not reproduced, descriptions of the individuals involved in this case and threatening behaviors toward them are unlikely to cease. The Colorado Judicial Department does not have the technology capability to monitor participation in live streaming, let alone the staff to then check various social media outlets to ensure no violations of admonition against recordings have occurred. It will be judicially economical to proceed with citations for contempt. It would not be judicially economical to proceed with citations for contempt of court against all the offending observers, even if true identities of each could be ascertained, which is unlikely. And it would be unfair and perhaps unconstitutional to proceed with citations for contempt of court against only those individuals, like JLR investigates, whose true identities can be known. Finally, nothing in this order prevents the credential media from reporting on this case pursuant to the order preemptively granting requests for expanded media coverage, which will be amended to accommodate credentialed media who previously used the live stream. Furthermore, the public is welcome to observe the proceedings in person. Orders. Therefore, the defendant's unopposed motion to cease unmonitored live streaming of court proceedings D-009 is hereby granted. Nothing in this order changes the manner in which any victims, the defendant's family, or staff of the respective attorney's offices may access this proceeding. Credentialed media may access and report on the proceeding as outlined in the amended order preemptively granting requests for expanded media coverage. Member of the general public may attend the proceedings held in open court in person subject to the following conditions. Only so many people will be permitted to enter the courtroom as can safely fit in the public gallery, less accommodations for the victims, the defendant's family, and the row reserved for credential media. Members of the public will not be permitted to bring into the courthouse any cell phone, laptop, tablet, or any other electronic device capable of recording. Members of the public must comply with all verbal written instructions given by security or law enforcement. Any person, including members of the public, credential media, a victim, a member of a defendant's family, or a member of an attorney's staff who records photographs or otherwise behaves in a contradiction of this order will be removed from the courtroom, will not be permitted to attend future proceedings, and may receive a citation for contempt of court. As this case continues, I may reinstate the ability to view certain proceedings via live streaming depending on the circumstances and the particular hearing, done and signed 27th day of October by the court. So there is that. I will leave y'all with that. I can say that Sandra had taught me how to do my emails to do live streaming, and I had already sent a live stream email request. So I don't know what's going to happen because this was one I wanted to follow. So we will see. With that, y'all have a great rest of your night. Enjoy your day. Peace. Rubber out.
Lights are